Northern Group writes NJC demands Justice Isa Abdullahi punished for aiding corruption. The Northern Ethnic Youth Group Assembly NEYGA NEGA has asked the National Judicial Council NJC to investigate Justice Isa Abdullahi Jamil of the High Court of Kogi State Lokoja Judicial Division for abuse of powers in a case involving the former governor of Kogi State Alhaji Yahaya Bello. The Northern Group made the request known in a statement issued in Abuja on Saturday. Spokesman of NEYGA Nega Alhaji Damusa said orders granted by Justice Isa Abdullahi Jamil are not only illegal but constitute a gross abuse of judicial process and powers in the light of judicial decisions. The group argued that the injunction granted by Justice Isa Abdullahi Jamil is a daring slap on the face of the Supreme Court, the Constitution, and the judiciary, and should be punished to deter others from following the same steps. The statement reads, and I quote, "There are at least 5 settled principles of law violated by the interim injunction. First, the High Court of Kogi State lacks the requisite jurisdiction to entertain any subject matter or question relating to the administration, management, or control of the federal government or any of its agencies, including the Economic and Financial Crimes Commission, EFCC, and ICPC. The operation and the interpretation of a constitution insofar as it affects the federal government or any of its agencies, and any action or proceeding for a declaration, order, or injunction affecting the validity of any executive or administrative action or decision by the federal government or any of its agencies. By virtue of Section 251, 1P, Q, and R of the Constitution of the Federal Republic of Nigeria 1999 as amended, the jurisdiction over the subject matter listed in the preceding paragraph is conferred exclusively on the Federal High Court. For ease of reference, the following cases are apt: NEPA versus Adegberu 2002, 18 NWLR Part 789. 69 Benson Agbule versus Wari Refinery and Petrochemical Co. Limited. 2013 6 NWLR Part 798. 78 Olutola versus University of Ilori 2005. 3 MJSC 150 at PP 173 to 174. Inegbedon versus Selu Ojeme and Ano 2013. All FWLR Part 688. 907 at PP 922 to 923, and very recently John Shoy International Limited versus Federal Housing Authority unreported appeal number XC 98/2005, delivered July 2016 by the Supreme Court. It is beyond argument that a suit instituted by the wanted Yahaya Bello, who is on the run, and the orders made by Justice Isa Abdullahi Jamil clearly offend the provision 251 P, Q, and R of the Constitution of the Supreme Court authorities cited supra. The subject matter in the case relates to the operation and the interpretation of a constitution as it affects the EFCC and the ICPC, both of which are agencies of the federal government. The interim injunction affects the validity of the administrative actions of the anti-corruption agencies. The law is now firmly established that proceedings, no matter how well conducted, and orders made by a court without jurisdiction are a nullity. The locus classicus on this is Madukolo versus Nkem Delim 1962 to SCNLR 341. On the power of federal law enforcement agencies to investigate the state government, this is an issue resolved by the Supreme Court in the case of Attorney General of Ondo State versus Attorney General of the Federation 2002. 9 NWLR Part 772 222, relying on Section 4 4 and 15.5 and items 60A and 67 of the first schedule to the Constitution and other enabling provisions, the Apex Court upheld, validated, and sustained the ICPC and its Establishment Act and dismissed the argument canvassed by Ondo State. The decision was followed consistently in subsequent cases on the subject. The power to prosecute economic crimes is exclusive to the federal government. It is not shared with the state. See the Supreme Court decision in Nyame vs. Federal Republic of Nigeria, 2010, 11 NWLR Part 1193, 344. In the Amadi vs. Federal Republic of Nigeria, 2008, 18 NWLR Part 1119, 259 at 276, Mukhtar JSC, as he then was held that, indeed, the EFCC is a common agency for both the federal and state economic and financial crimes. In the light of the position of the law as encapsulated above, it is most shocking, regrettable, and embarrassing that Alhaji Yahaya Bello, who until January 27, 2024 was the Chief Executive of Kogi State by virtue of Section 195 of the Constitution, purported to set a precedent over an issue that the Supreme Court of Nigeria has settled. The injunction granted by Justice Isa Abdullahi Jamil is a daring slap on the face of the Supreme Court, the Constitution, and the judiciary, and should be punished to deter others from following the same steps. On Thursday, Justice Isa Abdullahi Jamil ordered the chairman of the Economic and Financial Crime Commission, EFCC, Ola Olukayede, to appear in court on May 13, 2024, for allegedly disobeying court order. Justice Jamil delivering a ruling in suit number HCL 68M 2024 and motion number HCL 190M 2024 ordered that the said act was carried out by the respondent EFCC in violation of the order, which was valid and subsisting when they carried out the act. The same act of the respondent amounts to contempt. Justice Jamil's order was based on a motion expletive filed by Yahaya Bello through his lawyer, MS Yusuf ESQ, where he prayed the court for an order to issue and serve the respondent, the EFCC chairman, with Form 49 notice to show cause why order of committal should not be made on Olukayede. Delivering his order on the motion on April 25, 2024, Justice Jamil said, and I quote, "The applicant's application before me is to the effect that the respondent has carried out some act upon which they have been restrained by this court on the 9th of February 2024, pending the determination of a substantive motion and notice before this court." All this English, they scatter my brain. Make them tell us what will be the problem now. Lawyers, now they try you. Ha! Alright, on this note, you've come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy.